When should you file a patent application for your invention? That's a question I get a lot. The short answer is simple: as soon as possible. Hey everyone, welcome back to the channel. If you're new here, I'm Mark Trenner, a solo patent and trademark attorney. Let's dive into this topic, starting with the first to file race. A lot of inventors assume that if they were the first person to come up with an idea, they automatically own it. But U.S. patent law operates on a strict first to file system. It doesn't matter who came up with the idea in their garage first. It only matters who wins the race to file their patent application at the USPTO. If a competitor independently invents the same thing tomorrow and files their patent application before you do, they get the legal right, not you. There's also a legal clock that you need to know about that starts ticking the moment you share your invention with the world. I often hear a scenario like this from a client who's looking to file for international patent protection. They'll say, "Mark, it's important that we protect this in all major foreign markets." So I ask, is it still confidential? The answer I get sometimes, well, no, we have it on Kickstarter or our website, but it's only been out there for the past week. Unfortunately, most foreign countries do not offer any grace period at all. If you pitch your product publicly or launch a Kickstarter before filing a patent application, you instantly lose your ability to get patent protection in many foreign countries, if not most. Now, in the United States, you have a 1-year grace period from that exact date you first offer for sale, publicly disclose, or publicly use your invention. If 1 year passes, though, without you filing for your patent application, your invention enters the public domain and you lose all rights to that forever. You wouldn't believe how many inventors come to me and say, "Hey Mark, I have this idea for an accessory that attaches to the bumper of your car. I came up with the idea about 3 years ago. I built a prototype and I have it on the back of my car, and it's been there all this time." On the back of your car, I guess? That means it's been publicly disclosed for more than 1 year. You can't file a patent application anymore. Even if they're within the 1-year grace period, there's another trap you need to be aware of. The 1-year U.S. grace period is not the same thing as reserving your place in line for a year, like with a provisional patent application. Here's what I mean. Imagine Joe launches a new hardware product on Kickstarter. He knows he generally has up to 1 year after his own public disclosure to file a patent application in the United States. So he decides to test the market before spending any money on a patent application. 6 months later, a competitor sees the opportunity here and develops an improved version of that product, something Joe's Kickstarter campaign never disclosed, and the competitor puts their product out there on Amazon. Joe finally files his patent application at month 11. His own Kickstarter disclosure may be protected by the grace period, and the competitor generally can't simply turn Joe's previously disclosed subject matter into prior art against him. But the competitor's new features can be prior art. Those intervening improvements may prevent Joe from obtaining the broader claims he could have pursued if he had filed before taking that public. That's why relying on the grace period can be dangerous. It may prevent your own disclosure from hurting your U.S. patent application, but it does not freeze the prior art landscape and what others are doing during that 12 months. So what's the solution, you ask? I know what you're thinking. I'm still testing my prototype, and full patent applications require real investment that I'm just not ready for until I see that this thing will work. All right, this is where the provisional patent application becomes your best friend. A provisional patent application allows you to plant your flag at the patent office quickly and affordably. It costs a lot less than a full non-provisional. And it secures your official priority filing date and gives you patent pending status for a full 12 months. That gives you a year to test the market, pitch your investors, take your invention, put it out there, get some market feedback, and even refine your product while you're still keeping your rights locked down so no competitor can beat you to the punch. Forget the myth of mailing yourself a sealed letter. A poor man's patent, as it's called, does not provide any legal protection at all. And waiting out a grace period, like we talked about with Joe, that's a dangerous game. If you have an invention that you care about, you think it might be worth something, don't leave your priority date to chance. If you'd like to find out if I can help you, schedule a strategy session with me, and let's make sure your rights are protected. And hit the like button and subscribe for more patent tips. I do this every Friday.